Very good evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. A very good evening to all of you, dear friends. So friends, welcome to this very important session wherein we shall be discussing about some important legal maxims. We are conducting a series of total 10 sessions wherein we shall be extensively discussing with you various important legal maxims which are absolutely crucial for each and every one of you preparing for CLAT 2025. So since CLAT 2025 students have around 1.5 years of preparation time, it is absolutely necessary for each and every one of them to understand these important basic legal maxims. Now these are all legal terminologies which has an embedded principle of law underlined. So every legal maxim has a particular principle of law. So judges and lawyers, as you know, they speak sometimes a particular certain language which is unknown to the rest of the world. So what are the meaning and the definition of those words that are generally used in the courts by the judges and by lawyers? So guys, let's get started. A very good evening to all of you. Tulika, Garima, Akansha, a very good evening to all of you guys. So guys, let's get started. Okay, fantastic. Now, a very important announcement to make is the fact that CLAT 2024 6 hours non-stop marathon. It is going to happen on 29th of July at 11 a.m. This is the second marathon that we are conducting, 6 hours non-stop marathon for CLAT 2024. So those of you who are preparing for CLAT 2024, do not miss this mega marathon which is to be conducted on 29th of July at 11 a.m. onwards. Okay, this will be conducted by Abhimanyu sir, Nivedita ma'am, Alpha ma'am, Krishnendu sir, as well as Ankur sir. All the 5 faculties will be there to take this marathon. So guys, let's begin. Consensus ad idem. Consensus ad idem means same thing in the same sense. Now, agreement, when we enter into a contract, we have to agree on the same thing or in the same sense. Now, suppose tomorrow I want to sell my house. Now, there is a very famous case. I think it was a question in NLS Bangalore. So, here was a particular individual who had his dog, his house, and his wife all named Rani. So he had a dog called Rani, he had his wife called Rani, and a house called Rani. One day he comes up with an advertisement and says that I want to sell Rani for 50,000. Now, he has 3 things in the name of Rani: wife, dog, house. Now, of course, you cannot sell your wife. House and the dog, which is that thing that you are trying to sell? So when you are entering into a contract, you must agree on the same thing in the same sense. That is what we understand by consensus ad idem. So this deals with the concept of law of contracts. Is that clear? The law of contracts. Now, 𝗟𝗏𝗪 and Nikhil are 2 parties willing to enter into a contract. 𝗟𝗏𝗪 intends to sell his land situated at locality X to Nikhil for 10 lakh, whereas Nikhil understood 𝗟𝗏𝗪's land situated at Y. Now, a person has 2 pieces of land, X and Y. He says that I want to sell my land for 10 lakh. I mean X, he means Y. So in this situation, this is not a valid contract because there was no consensus ad idem that was reached between the two parties. Have I made myself clear? So whenever you are entering into a contract, you must agree on the same thing in the same sense. Okay. Yes, there should not be any confusion. Yeah. There should not be any confusion. Garima, very good. Yes, meeting of minds. Correct. Fantastic. Okay, let's move on to the next one. Allegens contra non est adjudium. It simply means a person who is saying two different things should not be heard at all. Now, suppose there is a criminal trial. I'll just give you an example. Suppose there is a criminal trial. A witness once says that, I was there in the spot at 5 o'clock. Another day he says, no, I was not there at 5 o'clock. I was in office at 5 o'clock, but I was there at 10 o'clock. A person who is making contradictory statement, he should not be heard by a court. Is that clear? जो इंसान कॉन्ट्रडिक्टरी स्टेटमेंट कहता है उसको तो कोर्ट सुनेगा ही नहीं. So there is a contract dispute between two parties, A and B. A claims that he have fulfilled all their obligation under the contract and is entitled to pay for the full payment from party B. However, party B alleges that party A did not perform their duties and required. As a result, they suffered losses, seeking damage from party A. Now, if party A later changes their stance, if party A is later changing its stance and argues that, in fact, he did not complete their obligation due to certain reason. Initially, what did he say? I completed all my obligation under the contract. Later on, he says, I did not complete all, but I did most of it. So there is inconsistency. A person is changing his stance. Then the court will not hear party A. Is that clear, every one of you? So if you are making contradictory statement in a court of law, the moment you are making contradictory statement in a court of law, you will not be heard. As simple as that. Is that clear, every one of you? So guys, if you are liking this session, do press the like button. Okay? If you are liking this session, do press the like button, guys. Okay? He was changing a statement which is not right at all. Yes, Akansha, absolutely. Okay. Moving on to the next one. Abundance, caution, non-nocet. It simply means if you take abundant caution on something, it does not cause any harm. Now, whenever we are entering into a contract, whenever we are doing any act, we must be absolutely conscious about what we are doing. You must take all precautions. You must take all necessary precaution so that, later on you do not cry over a spoiled milk, right? So that is what it is meant. Abundant caution does no harm. The phrase suggests that being overtly cautious or taking extra precaution is not a bad thing and does not result in negative consequences. It emphasizes the importance of being careful, prudent in one's action, decision, and endeavor. Is that clear? So whenever we are entering into a contract, suppose you want to enter into a contract with someone, know what is his financial condition, what is the good things about him. You should have a good idea about the person so that later on you don't say, hey, I wish I had taken those extra precaution before suffering some losses, right? Is that clear, everyone? Am I clear, everyone? सभी को समझ में आ रहा है? Yeah. Okay, chalo. Can we move ahead? Okay. Okay. I think Pranjali is there to answer everyone. Great. Brilliant. The next one. False in uno, false in omnibus. False in one thing means false in everything. It's a very simple thing. If one statement is false, suppose you have given a statement to the court, and suppose the court finds out that one thing in that statement is false, then the court is not going to look at any of your statements. Suppose you have filed an affidavit. Suppose you have made a statement on oath before the court, and the court finds out, forget perjury. Suppose the court finds out that one statement is false. So the court might tomorrow say, I'm not look at any of your statements made by you. Because if a witness lacks credibility, very, very important. If a witness before the court lacks credibility in one statement, then the truthfulness of the entire statement that he makes before the court is questionable. And henceforth, false in one thing means false in everything. Am I clear? Is that clear, every one of you? Is that clear, every one of you? Any doubt, you are most welcome to ask me. Any doubt if you guys have. So, when you are making a particular statement in a court of law, you must be careful that if one statement goes false, then the court might reject all your statement. Okay, very good. The next one, lex non cogit ad impossibilia. It means law cannot compel you to do something that is impossible. Can the law tomorrow compel you to do something that is impossible? Now, there is a construction company. Let's see the example. They have contracted to complete a project building within a time frame. However, due to a natural disaster like an earthquake, the construction site suffered significant damage. And owing to this genuine problem, this company could not complete its construction within the agreed time frame. Now, can tomorrow the court say, oh, you had promised that by so and so date you are going to complete the project, but you did not? There was some earthquake, a severe earthquake which damaged the entire thing. Right? Now, suppose there is a construction thing going on in Himachal Pradesh. Now, suppose there was a contract and the contractor said that within 15 days, I am going to construct this part of this road. But owing to this flash flood, whatever flood that came, there was a huge disaster in Himachal Pradesh, right? Now, is it possible for the contractor to complete his work? No, it is not, because it is now impossible because everything got destroyed, right? I hope I am making myself abundantly clear. We should be careful while talking to court. Statement could not be changed frequently. Yeah. You see, in this particular sense, I would say that the law or the judge cannot force you to do something that is impossible. Simple. Okay. Let us move on to the next one. Okay. The principle of lex cogit ad impossibilia would come to play, and the company may be excused from penalty for not completing the particular project. Is that clear, everyone? I hope that I am abundantly clear to each and every one of you. Okay. Moving on. Now, a very, very important announcement. BYJU'S exam prep brings to you a CLAT 2024 6-hour non-stop marathon. It is going to be conducted on 29th of July from 11 a.m. onwards. So do not forget or do not miss it. The next one, 𝗟𝗄 𝗙𝗃 non orito actio. It means no action can arise from an illegal act. Now, if a person does something illegal, okay, suppose there was a contract. I'll give you a simple example. Suppose I entered into a contract with two of my friends that tomorrow we are going to rob a bank. And one of the clauses of the contract says that if anybody fails to join the robbery party, he will have to pay 5,000 rupees as compensation. Now, suppose Mr. A does not turn up for the robbery act. Can I tomorrow go to the court and say, hey judge, we three entered into a contract to rob a bank. I and B were there, but A did not come. Under the contract, A is liable to pay 5,000 rupees. Direct him to pay 5,000 rupees. Simple. No action can arise from an illegal act. As simple as that. As simple as that. It's a kind of act of God. Yeah. Is that clear? There is a person named Yatin who decides to rob a bank. While attempting to carry out robbery, Yatin slips and falls, sustains serious injury. Now Yatin wants to sue the bank for negligence, claiming that the bank's floor were slippery and caused the accident. There cannot be an action because you have yourself committed an illegal act. Yatin's claim for compensation would be barred because he was the man who did an illegal act. So how can you now claim something out of an illegal act? Is that clear? Every one of you. Is that clear? Every one of you. Okay. Okay, fantastic. Moving on. The next important maxim, actus me invito non est mens action. It means that an act done by a person against his will is not his act. Now, if someone tomorrow puts a knife or puts a pistol on my head and says that you have to commit a particular crime, you have to commit theft, or suppose a person kidnaps my child and says that if you do not help us rob a bank, we are going to kill your child. Now, although I am doing that robbery, that act, the court will not hold me guilty because I am doing something against my will. Varun at gunpoint forces Rishi to assault Karan. If Rishi assaults Karan, then the act of Rishi will be said to be not free and it's done. So it's a kind of coercion, okay? Something like coercion. I'm sure that you must be aware of the term called coercion by now. Is that clear, everyone? Is that clear, every one of you? Every one of you. Okay. Fantastic, fantastic, fantastic. That's good, that's good, that's good. So, I'm sure that you guys are right now in a position where you understand these meaning of these legal terms. The next one is ratio decidendi. The word ratio decidendi means the reason. Now, we follow the common law system, okay? And when a judgment comes from the court, we just see judge ne finally kya bola. But we must also look at the basis of the judgment, the reason behind the judgment, the reason behind the judgment. The reason behind the judgment or the rationale for the decision is called ratio decidendi. It represents the legal principle or rule which was followed by the court And on what reason has the court come to a particular decision? Now, it is the binding part of the judgment, and it serves as a precedent for future cases. Am I clear? So, the ratio is the reason behind the judgment. It is that part of the judgment which is to be followed as precedent, whereas obiter dicta is the other thing which is not to be followed too much. Is that clear, everyone? The reason behind the judgment, Garima, it's not the facts of the judgment, it is the reason behind the judgment. The reason behind the judgment. Am I clear now? The reason behind the judgment. The reason behind the judgment. Okay? Okay, all of you? Okay, before we move on to the next, another couple of important maxims, BYJU'S exam prep brings to you a free live interactive workshop happening on 30th of July at 6 p.m. Accelerate CLAT success, conquering the exam in 5 months. So what should you do and what should you not do in the next 5 months for CLAT 2024? Next, ignorantia juris non excusat. Ignorance of law is not an excuse. Now, if you are not aware of a law, if you do not know a particular law, can you be excused even if you violate that law? The answer is simply no. Now, suppose the speed limit of a particular road is 50 kilometers per hour, and you are not aware that the speed limit is 50 kilometers. So what do? You drive at 80 kilometers per hour. You are caught. Can you tomorrow say that, police officer Sahab, I was not aware that this road, the maximum speed limit is 50 kilometers per hour. If I had knowledge, then I would have definitely kept my vehicle below 50 kilometers. I had no knowledge of it. No, you will be punished. Ignorance of law is not an excuse. Ignorance of law is not an excuse. Am I clear? Is that clear, everyone? I hope that I'm clear to everyone. Okay. Is that clear? Sabhi ko? Okay. Let's move on to the next one. The next one is injuria sine damnam. The next one is injuria sine damnam. It means injury without damage. There is a violation of legal right, but no loss. So here we are coming with a particular very important maxim based on law of torts, civil law. Now, the law says that the moment a person suffers from a legal injury, he or she can claim compensation. The moment a person suffers from a legal injury, he has a right to claim compensation. Now, there is a very important case wherein a person who was eligible to vote in a parliamentary election, Mohan, who was eligible to vote in an election, was stopped by the returning officer, was disallowed by the returning officer wrongfully. Now, although the man or the party to whom Mohan wanted to vote won the election, now the question is, there was no loss, no financial loss, nothing, because वो मोहन जिसको वोट देना चाहता था उसी बंदे ने वो इलेक्शन जीत गया. So he did not suffer any loss. Now the question was, can he claim compensation? The courts have held across the world that yes, you can claim compensation owing to the fact that your legal rights were violated. Violation of a legal right. If your legal rights are violated, you can definitely claim compensation. Is that clear, every one of you? It's one of the very, yes, this is Ashby versus White. Yes, this is Ashby versus White. This is what we know as Ashby versus White. Very good. Yeah. It is Ashby versus White. Okay. Okay, fantastic. Great. Okay. Let me see any. Yes, ignorance of fact can be excused, but ignorance of law cannot be excused. Yeah. Okay. Moving on to the next one. 𝗘𝗴𝗴𝗹 per se. It means he who acts through another does the act himself. Now, this is a concept of vicarious liability. Now, the concept of vicarious liability simply says that if I tell my servant to do something, and while he is doing that act, if he commits something wrong, who will be held liable to pay compensation? The person who has asked the servant to do something. So the master will be liable for the wrong committed by the servant, provided the servant is doing the authorized act. And secondly, he is doing the act during the course of employment. So there is this concept of authorized act and course of employment. So he who acts through another does the act himself. A company XYZ owns a delivery service. The employee drivers to transport goods from one place to the other, one location to the other. One day, while making a delivery, one of the company's driver, John, accidentally causes a car accident. This damaged another vehicle and injures his occupant. According to the principle of voluntary non-fit or vicarious liability, who is to be held liable? The company XYZ. Because the company will be liable for the accident since the employee was working during the course of employment and he was doing an authorized act. Is that clear? 𝗟𝗲𝗴𝗹 says BYJU'S app is not working. I have not got any complaint as of now. But if you say so, I will definitely have a word with our technical team. If you say that BYJU'S app is not working, is it not working for everyone? Is BYJU'S app working or not? Tell me. Somebody saying 𝗟𝗲𝗴𝗹 has a saying that the BYJU'S app he's using is not working. I don't think so, because I am also using the same. It's working fine for me, Garima. So I think you have to refresh or delete it and then download it once again. Okay, it's working fine. Okay. Yeah. So this vicarious liability principle works in master servant, principal agent, and partners in a partnership firm. The next one, lex specialia derogata, lex generally. Now, if there is a special law, the special law will apply than the general law. Now, suppose there is a general law in India which says that the speed limit should be 40 is to be 40 kilometers an hour. But there is a special law which says that near schools, the speed limit should be 20 kilometers an hour. So if you are driving near the school, it should be 20 kilometers an hour. So a special law will overrule a general law. Am I clear? The general law is that in India 40 kilometer per hour. For example, of course you have the expressways, all these national highways where 80, 90, 100, 110, 120 is the speed limit. So I think the Mumbai Delhi expressway is around 120 kilometer per hour. But that is a special road. That's a special law. But generally in India, it is 40 kilometers an hour or 50 kilometers an hour. Am I clear? Every one of you. Have I made myself clear? Sir, if the employee's done an accident while out of working, no, then the master will not be held liable. Okay. Okay. Is that clear? This one. Every one of you. Okay. Okay. Let's not, Garima, let's not talk about reservation and all right now. We will do it in some other class. So, if a driver is driving through the speed during the school hours, both the general law 30 miles per hour in residential and specific law is 20 miles per hour, as I said. So, this principle of special law overrides the general law prevails in India. Okay, prevails. Very, very important. Any question, any doubt. Any question, any doubt. Okay. Okay. Is that clear, everyone? Any doubt? Okay, let's move on to the next one. Extraterritorium judice means beyond the territory of a judge. Now, every court has a territorial jurisdiction. Now, beyond the territorial jurisdiction is called extraterritorial jurisdiction, beyond the jurisdiction of a judge. Now, the Calcutta High Court cannot decide a dispute where the dispute has taken place in Delhi. The Delhi High Court cannot decide a dispute where the dispute has taken place in Madras. The Madras High Court is going to decide that. Now, if a dispute has taken place in Chhattisgarh, the Bombay High Court is not going to decide. Same concept. It refers, now, this is a general law, but sometimes we see that beyond the boundaries, court may have to extend its jurisdiction. Now, there are certain laws which says that, the Indian Penal Code says it's a great statement which says that if an Indian commits a crime anywhere in the world, the Indian Penal Code will be applicable. So, if an Indian guy goes to South Africa, commits a murder, will the Indian court have jurisdiction? Now, these are debatable topics. Let's not, because these will all entail international law concepts also. It refers to a situation where a court exercises its jurisdiction over matters that occurs outside its geographical territory. In legal system, courts typically have jurisdiction. Now, however, in some circumstances, court may extend its jurisdiction beyond its border, leading to the concept of extraterritorium judice. Is that clear? Next, res nihilus naturalitatea fit prima occupanti. It simply means a thing that has no owner belongs to the first taker. Now, suppose there is a 10 rupee note that you find while you are going to school. Nobody. You have a title over that property except for the owner. अगर real owner आते हैं तो आपको देना पड़ेगा. बट अगर रियल ओनर नहीं आता है वो 10 रुपया के लिए वो आपका हो गया. So, suppose there is an uninhabited island that has never been claimed by any country or individual. According to this doctrine, the first person who enters the island becomes the owner of the island. Is that clear? But no, suppose you go to a place and nobody has ownership of that land. You settle down, you become the owner. But I don't think in today's world with huge population, India has become the most populous country in the world. You will not find any such place in India at least. Okay. Pranjali Bilkis Bano's case was transferred from Gujarat to Maharashtra based on a transfer petition, because it was held that there was certain people who went to the court and said that in Gujarat she might not get justice. That's why the court transferred the matter to Maharashtra. Please, Pranjali. The next one, 𝗟𝗂𝗃 𝗟𝗄𝗃. It simply means, the meaning of a doubtful word may be ascertained by referring it to some associated things. Now, what is the meaning of a particular word? If that is doubtful, then you look for something that it is related to or is associated with. A suspect was found with drugs, guns, and other illegal items. In that sentence, the word drug is used in conjunction with guns and other illegal items. Now, applying the principle, we can understand that drugs in this concept is likely to be illegal drugs. Now, drugs also mean medicine. Somebody is caught with drugs, guns, and illegal item. Now, drugs also means डॉक्टर अपोलो फार्मेसी में जाएंगे, आप बोलते हैं इज ड्रगिस्ट भी बोलते हैं, काफी फार्मेसी को ड्रगिस्ट भी बोलते हैं, बिकॉज फार्मास्यूटिकल ड्रग्स भी होता है, medical drugs भी होता है. But in this concept we are talking about illegal drugs like, you know, all these cocaine, ganja, charas and all. Am I clear? Is that clear? So when you associate yourself those words with other words, you get the real meaning of that word. Am I clear, everyone? Am I clear to everyone? Okay, fantastic. So guys, BYJU'S exam prep brings to you a 3-day free trial access to all our courses. Go to the description box below, click and get unlimited access to all our courses just for 3 days. The next one is suppressible 𝗏𝗏. It means concealment of truth. Now, if you are concealing truth, that is a wrong. If you are deliberately, if you are intentionally leaving out the truth and misleading the court, it is called concealment of truth. Now, the duty of the judge is to find out the truth and give a judgment. Now, if a person is concealing the truth deliberately, he is trying to deliberately mislead the court. That is what is the meaning of concealment of truth. Am I clear? That is what is the meaning of concealment of truth. Am I clear? Okay. Guys, BYJU'S exam prep brings to you a 6-hour non-stop marathon happening on 29th of July 2023 starting at 11 a.m. Do not miss it. Okay. So if you are selectively withholding information which is important, that is called suppressing the truth. Is that clear, everyone? Next, void ab initio. Void from the very beginning. For example, a contract. If you are entering into a contract with a minor, that is void from the very beginning. A contract that is void from the very beginning is called contract void ab initio. A person, a minor, cannot enter into a contract unless he attains the age of majority, that is 18. So a contract with a minor is void ab initio. Because he or she does not have the legal capacity to enter into a binding contractual relationship as in the status of a minor. Is that clear, everyone? Okay. So guys, before we end, BYJU'S exam prep brings to you a CLAT 2024 comprehensive course wherein we are providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exam along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our analysis of the last 5 years of CLAT question paper. So guys, do subscribe to our YouTube channel. We are conducting classes every day on our YouTube platform. Do attend these classes. Do follow us on our Instagram. Do like our Facebook page. Join our Telegram channel. And do not forget to download the BYJU'S Exam Prep app today if you haven't. Thank you very, very much. Do like and subscribe to this session. Thank you. God bless you. Bye-bye. Good night. Thank you.